Hi, everybody. Thank you for joining us today. Just our quick standard disclaimer. This presentation is for educational purposes only. It is not legal advice and does not create an attorney-client relationship for anybody who's not currently one of our clients. We'll have some information at the end on contacting us if you have some specific questions. Just as a heads up, we're going to move through this stuff fairly quickly. And just as an overview, I've got 10 questions we're going to talk about that have been submitted to us that you will see if you're a subscriber to our newsletter. We have our little Flashback Friday question, our Flashback Friday box in our email. This is addressing some of those issues. So we're just going to hop right into it, folks. Question 1, which documents do we need to have new employees complete during the onboarding process? So new hire forms fall into two major categories. There's federal and state forms, which are required by law, and then there are standard new hire forms, which are specific to your company's human resources operation. So combined, those two groups of forms would make up the following list. So for federal, you need a Form I-9 and a Form W-4. For state hiring, you're going to have your state new hire tax forms, and you're going to have to report into the state when you hire somebody. Your in-house documents are going to include your offer letter, an employment agreement if applicable. Not everybody has that. An employee handbook acknowledgement, probably a direct deposit authorization, an emergency contact form, some other policy acknowledgements if they're outside of your employee handbook, benefits information you're going to have to provide, and then you may also use a new hire questionnaire. Question 2. In which states are we not allowed to ask prospective employees about their salary history? So just a little background real quick. This comes up because businesses in the past have used previous salary information to calculate new hire compensation, and it's been viewed by the government that process perpetuates pay disparity between men and women. So to address this inequality, one of the goals of these laws that ban asking about salary history is to help close the gender wage gap. A lot of times women start out earning less than men in their careers, and then that can follow them through the process when people are reviewing their salary histories. So it's illegal statewide in the following states to ask for compensation history during the hiring process. I'm just going to list the states. So it's Alabama, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Nevada, New Jersey, New York, North Carolina, Oregon, Pennsylvania, Rhode Island, Vermont, Virginia, and Washington. Some cities also have salary history bans like New York City, San Francisco, New Orleans. The rules on this are changing all the time, so if you've got a question on a specific area, it's always best to reach out to us. Question 3. What changes do we need to be aware of with the new Form I-9? So the new I-9 form for new hires and rehires goes into effect on November 1st of this year, so in about just under 3.5 weeks. The new form is considered like a 1+ page document versus 2 pages like some previous versions. I'm just going to talk real quickly about the changes, and then we'll move on to the next thing. But there's a lot of stuff that's changed actually. Sections 1 and 2 will now be on 1 page to help kind of simplify the process. There will now be a remote examination checkbox that allows employers who are enrolled in E-Verify to indicate that they have examined the employee's identity and employment authorizations remotely. But again, you have to be part of E-Verify to do that. There's going to be a new re-verification and rehire section, formerly known as Section 3. It's been moved, basically. Also, the preparer and translator certification area has been moved to a separate page, now called Supplement A. There's some wording change in the document. They're no longer using the term alien. They are now using the term non-citizen. There's also going to be an updated list of acceptable documents that can be used when you are examining somebody when they're being hired. The new I-9 form, again, effective as of November 1st of this year, will have a more mobile-friendly design, meaning it can be used on tablets or other mobile devices. And finally, there's going to be some additional streamlined instructions. It's going from about 15 pages down to 8. So that is just kind of a heads up on the new I-9 form. Question 4. What can we do if we have completed the ADA interactive process and can't find a way to accommodate an employee? So as an overview, if an employee has a physical or mental issue that prevents them from performing the essential functions of their position, an employer has an obligation to go through the ADA interactive process. If the interactive process reveals an employee can't perform the essential functions of their position with or without reasonable accommodation, and that presumably means that you've tried some accommodations and also looked at reassignment as the accommodation of last resort, then the employee does not have to be accommodated or employed. But before letting somebody go, an employer wants to make sure that they've documented all communications with the employee and any attempts that they've made to accommodate the person. If you're letting somebody go who's been involved in the ADA process, a lot of employers elect to use a separation and release of claims agreement for someone where an accommodation is not possible. Under that arrangement, the employer pays severance to the employee in exchange for the employee signing off on an agreement that limits which claims they can bring against the employer. It's not required to use a separation and release of claims agreement with severance pay, but sometimes it's a good idea to help reduce risk. Question 5, are we liable for a workers' compensation claim if a remote employee injures themselves by falling down the stairs at their home during business hours? The answer to that question is quite possibly yes, but it will depend on the workers' compensation laws in your state. Generally speaking, work comp insurance is going to cover employees' injuries arising out of the course of work. While working at home, an employee is allowed to take rest breaks, basically, during work time to use the bathroom, get a drink of water. That's allowed. That's work time. Whether an injury that occurs during those activities, however, whether it's compensable under the work comp laws will depend on the laws in the particular state where the employee is working. So if you've got an employee that's injured while working at home, the claim must still be submitted to your work comp insurance carrier. The carrier then will investigate the circumstances of what happened and determine if the work comp insurance coverage will apply. And again, that will be based on state law. Question 6. Can we require that an employee have their own set of tools for their job? Well, the answer to that is maybe, or as stated on the previous slide, it depends. Some specialized jobs, if you think of like an auto mechanic or maybe like a finishing carpenter, those jobs may require that an employee supply their own personal tools. With carpenters specifically, some larger general contractors may supply some of the tools, but that is often not the case with auto mechanics. They are frequently required to supply their own tools. Other types of jobs might supply all the equipment needed. If you're like an office worker, for example, you're going to get a computer, you're going to be able to use a printer, a copy machine. There'll be desk chairs and office supplies, but if you're a specialized skilled laborer, such as an auto mechanic or a skilled carpenter, you may have to supply your own tools. Question 7. At what point, if any, can we ask an employee for a doctor's note if they continue to take sick days? Okay, well, the answer to this question is going to be what everybody loves to hear when they speak with an attorney. It depends. The reason I say that is some states have paid sick leave laws, such as California, which have rules on when an employer can ask for a doctor's note. In California, under their state paid sick leave law, for example, it's only after 3 consecutive days of workplace absence. So that is built into state law. In states without restrictions on asking for a doctor's note, an employer can set their own policy. Most employers would choose, from what I've seen, 2 to 3 days. But the thing you've got to keep in mind is if you're setting your own policy, the policy has to be applied consistently to all similarly situated employees. In other words, you can't pick and choose who or when you ask for a note if you've got a policy in place. You've got to follow the policy for everybody or you're risking different types of employment claims. Question number 8. What is the legal requirement for an employee to be classified as a full-time employee? Again, sorry folks, it depends. Most employers require 40 hours per week to be considered a full-time employee. That's just a standard that the employer themselves set. Other employers set full-time hours at 37.5 hours per week, 36 hours per week, or even 32 hours per week to be considered full-time under the employer's own internal policy. But you've got to remember that whatever time frame you set for an employee to be considered a full-time employee based on number of hours they work per week, you're going to be still subject to various state and federal laws regarding wage and hour rules for your employees. For example, the Federal Fair Labor Standards Act requires overtime pay to non-exempt employees working more than 40 hours per week. Some states such as California and Colorado even have daily overtime rate for employees working more than a certain number of hours in a particular workday. So in those states, even if you say, well, a full-time employee is 32, 36, 37.5 hours per week, you could still end up owing overtime pay if those employees exceed the daily or weekly overtime rules. You know, you've got a 32-hour per week employee. There's a couple days they've got to work 10 hours. If they work in California, they're going to get daily overtime for their work performed, even if they don't work 40 in a work week. Also under the Federal Affordable Care Act, also known as the ADA, that sets a standard for full-time employees that employers need to be aware of. Under the ACA, for purposes of the employer shared responsibility provisions, a full-time employee is, for a particular calendar month, an employee employed on an average of at least 30 hours of service per week or 130 hours of service per month. So it wouldn't matter if you said as an employer, hey, they only work 30 hours a week. They're not full-time employees under our internal system. Under the rules of the ACA, they would be considered full-time employees and the employer would be subject to that law. So that's something that you're going to want to check into if you have any questions. Question number 9. Are articles of clothing, buttons, or stickers worn or displayed by employees protected as free speech? And free speech is in quotes. So just as an FYI, a free speech issue generally doesn't come into play with private employers. Free speech laws in employment relate generally to what government employers have for the rules. So that could be a city, that could be a state, that could be a school district, a university. Those public employers have a burden of free speech laws because they are government employers. So for private employers, free speech restrictions on clothing or stickers can be more wide-ranging. But the thing to keep in mind, even for private employers, that the National Labor Relations Act doesn't just apply to unionized workplaces, it applies to private workplaces as well, because union activity couldn't occur in a private workplace. So the NLRA covers not just unionized workforces, but non-unionized as well. So generally speaking, what does that mean? That means that pro-union buttons generally can't be prohibited under Section 7 of the National Labor Relations Act in private workplaces. Private employers may also not be able to prohibit certain religious-based clothing unless it presents a safety issue. So an employer could prohibit certain religious-based garb if it's loose fitting and it's around machinery, such as in a manufacturing facility. But otherwise, as a private employer, you're limited in your prohibition of union buttons, and you could only prohibit certain religious clothing if it came down to a safety issue. And question 10, if an employee disputes the results of a drug test, do you recommend allowing them to test again? Okay, here's the answer. It depends. Whether or not to allow a second test will be determined by your regular policies and practices with drug testing, so the policies that you set. Applicants and employees who are subject to drug testing must be treated in a consistent manner. So certain applicants or employees can't be singled out for testing. Like, we don't like Johnny, he looks kind of funny, we're gonna always test him and nobody else. You can't do that. Testing must apply equally to all similarly situated individuals. So an employer needs to follow a regular process, including whether or not to allow a second test. But also, keep in mind that some states, such as Iowa, Minnesota, and North Carolina, they have drug testing laws where a second confirmatory test is allowed or permitted by law. So in addition to your own internal policy with drug testing and a potential retest, you've got to be aware of state law as well. And if you operate in certain states, a retest will be allowed or actually required by law. So in summary, there's a lot of variables involved under the law. There's variation from state to state. There's also variation between federal and state law. Some of the answers to the questions we receive are fairly straightforward. Others require more interpretation, more nuance, and are a little more complex. I think the best course of action for employers is when you've got an issue that comes up, you're not sure, run your question by us. If you're already a client, shoot us a message through our Ask HR portal. We're always happy to get into it with you and explain something that might seem simple on its surface, but maybe is not. If you're not currently a client and you'd like to sign up, check out our website as noted on our next slide here. Remember, everybody, compliance is not optional. Thanks very much for attending today. Reach out based on the information on your screen, and we look forward to speaking with you again soon. Thank you.